So I'll just make, so this will just, so Nakia, you might just have to nudge me to advance the slides if I fail to do so at the right time.
Okay, I will.
So how's Ethics Week been going?
I think it's been going well. It's
Yeah,
flew
so
by. I
far
can
so
tell you
good.
that.
Huh? And
Rashee, what do you think?
Yeah,
yeah,
it's been so far so good. It's
Good.
like it's been pretty good.
and your presentation went well earlier this week, Asia?
Yes, it went well. I got some good feedback, so that's good.
Oh,
Especially
that's
since
good.
I was like putting the finishing touches on at the very last minute.
Right. Well, it's hard when you come back from 2 weeks out of the office and it's like, whoa, game face.
Yeah,
So
really. And I came back on Friday evening, so I had only the weekend, and so I was just like, but it worked out.
where did you go?
I went to Europe.
Oh, wow.
I went to London, Paris, Rome, and Mykonos.
Gosh,
So,
that was like a real tour.
yeah, it was. We tried to hit the hot spots.
I bet this was a good time to go. I mean, in terms of not too crowded and
Yep. Yep.
Greece
It
has
was
been
excellent.
so
We
hot
didn't,
in this. Yeah.
first of all, it was hot.
Yeah.
It
It
was
was
like
still hot.
70s and 80s everywhere.
Okay. Okay.
But we didn't have to wait in any
Yeah.
lines. Anywhere we wanted to eat, we could just walk in. So that was great.
Amazing.
Yeah, it was really
Very
good.
good.
Erika, how was your trip?
It was good. I was just, visiting family. So we went up to Toronto to see my in-laws and then came back and went up to Kennett Square, Pennsylvania to see my mother. And the kids had this strange fall break this year where they got a full week off and I was kind of didn't want to see the time be completely unproductive for them. So
Yeah, we had that last year. I think this year, instead of doing the whole week, we just get like scattered Fridays.
I
Of
don't know,
like,
which is
November
I mean,
3rd. Like,
yeah.
I have to work November 3rd, but thank you.
My kids are old enough, I don't really need childcare, but I still don't want to sit there and watch them on their phones all day, like sitting around the house for days on end.
Yeah.
So
Last week, Thursday, Friday was off. Like,
I had some friends who were,
cool.
yeah,
Thanks for
just
that.
3-day week out of nowhere, right?
Mm-hmm.
Have people been kind of breaking in to ask questions during the presentations or?
Mostly through the chat, it seems like.
Okay.
If we want them to be able to talk, we can make them all panelists. Is that something we want to do? Because I can tell Kevin, our IT guy, to come in and help us with that if we want them to be able to talk.
What do you think, Nakia? I think
Mute.
you're, yeah.
So I think the chat is probably the best way.
Okay.
Is there a way to unmute them at the end, or is it an all or nothing kind of a thing?
As far as I know, and this is my limited IT experience, they have to be changed to panelists one at a time. So
That's a lot. Okay.
if we want it at the end, I can maybe send him like a quick message to do it like when we're like 10 minutes out or something to start transitioning them all to panelists.
There's an option I can see. It says mute all, but there's not an unmute all.
Yeah.
Maybe better. Maybe we'll just let them use the chat, right, and encourage them to do that.
And then Asia and I can keep an eye on that.
Yeah, and they'll be voting, so hopefully they'll be using the chat throughout to kind of vote on hypotheticals and things like that.
Okay.
So we are using the polls, Erika?
I think they'll have to type their answers into the chat and we'll have to monitor it that way.
Okay.
So actually I was doing a WebEx just yesterday, and every system is different, but it looks like the same. And the chat, it was pretty easy to keep track of. We've got a lot of C's or A's or B's.
The last one we did, but that was with CLE, they actually put up the poll, right? Yeah.
That's a little extra IT expertise that I do not like to manage. I can avoid it.
Oh, yeah. I'm fine either way.
Oh. So do you guys think that, I mean, have there been some live sessions this year for Ethics Week, or has it all been online?
Yeah, we had some live sessions. We did
Yeah.
the director's introduction at the very beginning to kick us off. That was in person in
Okay.
council chambers at our work site. And then our Ask BEGA session where we have people pre-submit anonymous questions and we answer them. That was also in person. And then
Okay.
Rashee did yoga and ethics. I think that was on Tuesday.
Yeah.
That sounds like a good one.
I think we'll probably do hybrid again next year. Like some stuff in person and some stuff virtual.
Well, this would probably be a relatively easy one for us to do in person, just because it's so close to our office.
Mm-hmm.
I remember the old days of walking down and going to the big boardroom.
We'll keep that in mind. We had somebody else say that they wanted to do their presentation in person next year. So
Yeah.
hopefully we can get it where maybe we have like a whole day of all in-person courses.
Right. And that's the hard thing, right? You can't necessarily get people in for 4 or 5 days
Mhm.
classes in a row. That's a lot.
Yep.
All right, we're at about 2:15. Looks like we got 52 attendees and the number is going up a little bit. So if you'd like, we can wait another couple minutes, let some more people file in.
Maybe another minute or two, because I want to say we had about
Yeah, because we've
135 people
got
registered.
a lot of slides to cover, right? What did you say? How many? Like 100 or more?
135.
Oh, wow. Okay. Yeah. So we're about halfway there right now. And that number is steadily going up still.
We love the enthusiasm.
Let's see, we're at about 95, including us right now. Oh, okay, we got a note that the other training ran over a little bit, so maybe that's why. We're having
Okay.
more people join now.
So just yeah, just give us a sign and we'll get started whenever you think.
We are close to 100 right now. Aisha, what do you think?
Yeah, I think we can get started. 5-minute grace period should be fine. I was on the other one and it did go over. But I think people had a few minutes at least to get a bathroom break.
So, Rashee, did you want me just to get started, or were you going to read bios or anything like that? I mean, we can introduce ourselves if that's easier.
Yeah, no, that's okay. I've got the bios
Okay,
up
good.
and
Okay.
ready to go. So, all right.
Okay.
Well, welcome everybody to Ethics for Government Lawyers. You may remember me and you may remember Asia from all of the other panels you've seen this week. But we've got guests here from the DC Bar. Today we have Nakia Matthews and Erika Stillabower. Nakia Matthews joined the Legal Ethics Program at the DC Bar in 2019. As Senior Legal Ethics Counsel, she provides guidance to the members of the DC Bar seeking information on the interpretation and application of the DC Rules of Professional Conduct. In addition, she provides staff support to both the Legal Ethics Committee and the Rules Review Committee of the DC Bar. Prior to serving as Senior Legal Ethics Counsel, Nakia spent 4 years as a managing attorney at the DC Bar Pro Bono Center, where she served as a managing attorney for the center's bankruptcy, consumer law, and advice and referral clinics, and served as supervisor for the Landlord-Tenant Resource Center in Superior Court. Thank you, Nakia, for being here. Now, Erika Stillabower is Senior Legal Ethics Counsel at the District of Columbia Bar. Since 2013, she's provided guidance to the members of the DC Bar seeking information on the interpretation and application of the DC Rules of Professional Conduct. Ms. Stillabower contributes to columns on legal ethics that appear in the Washington Lawyer and regularly serves as faculty on CLE-accredited ethics courses. In addition, she provides staff support to the Legal Ethics Committee and the Rules of Professional Conduct Review Committee of the DC Bar. In connection with her committee work, she assists in drafting informal chair letters and published legal ethics committee opinions. Welcome. Asia, any other housekeeping matters before we get started?
Just a quick word. I sent out an email to all of the registrants about 10 or 15 minutes ago with the course materials and the instructions for getting the CLE credit. So just want to draw everybody's attention to that in case you hadn't noticed that email. Make sure you refer to that email for instructions. And if you haven't already, just take a quick look at it now because I think we're going to be giving out a code right throughout the course. And you're going to need that code as a part of those instructions. Is that correct, Erika?
So I think Brendan might have sent an email out about that, and I do not have that email pulled up in terms of the code.
Okay, I can resend it to you, but
yeah, or so, because I'm running the presentation, I don't think I'll be able to pull it up. But normally,
if you send it to me,
that would be great.
Pull it up.
Okay. Okay.
And I think in 1 hour sessions, we typically only do it at the very end, like in the last 10 minutes or so.
Got it.
So the main thing is just make sure if someone wants to put a little reminder on their calendar or something, just so we don't leave that off, because I know getting that CLE credit is very important and one of the reasons we have so many people sitting here right now.
Mm-hmm. All right. I'll send it over to Nakia so we can make sure we give it out.
All right. That said, I'll just launch right in here into the presentation. So I'm sure there are, I can't see anyone, I can't see any names, but I'm sure there are many familiar people in the audience now. I think this is probably at least the third year you've seen Nakia and me do this presentation. And in the past, I've done it with Hope Todd, who's the director of our ethics program at the DC Bar, and also with Saul Singer. Sorry, I just saw one comment about not getting course materials yet. I think you're probably better off because hopefully you won't be tempted to look ahead and guess at any of the hypothetical answers that we have here on our PowerPoint. And I'm sure it can be made available to you at the end. So I always like to make sure that people sort of have a list of resources. And for government lawyers, for DC government attorneys, I think your starting point for getting ethics guidance or guidance on any of your government ethics rules is going to be your agency or BEGA or the Office of the Attorney General. I know that there are good programs within the DC government that can really help you get oriented. At the same time, if you're a DC lawyer, you also can take advantage of the resources we have at the DC Bar Ethics Program. That would be, calling the ethics helpline and getting informal guidance from Hope Todd or Saul Singer or Nakia or me. That's probably the main. That's the primary responsibility, I would say, that Nakia and I have at the bar, is to give ethics advice on the fly. We also, of course, have two different committees. Some of you might have served on these committees in the past, the Legal Ethics Committee and the Rules Review Committee. The Legal Ethics Committee issues formal opinions, providing ethical guidance to lawyers as to, under various ethical scenarios. And of course, the Rules Review Committee is constantly looking and examining the DC rules of professional conduct and making recommendations for changes or modifications. And the ethics opinions, information about the legal ethics program generally, and the helpline can all be found on our website. And of course, I do always like to point out that we are not the Office of Disciplinary Counsel. We are an entirely separate arm of the bar. That is why we're able to give confidential guidance and listen to people's inquiries and offer them some confidentiality, because we are totally separate from the Office of Disciplinary Counsel, which has responsibility for investigating and disciplining DC lawyers who run afoul of certain rules. And these are sort of basic statutory interpretation guidelines or ideas. It's really important when we look at the rules to focus on whether it's a mandatory or a suggestive rule or a purely aspirational rule. And we'll be talking about rules, I think, throughout the presentation, some of which are serious in the sense that failing to abide by them can set a lawyer up for disciplinary action. Others, I think, fall more into, the prudential category. A best practice is to do X, Y, or Z. And that, while it might not, those types of rules might not carry disciplinary threats or the risk of disciplinary action, knowing those rules, complying with those rules, abiding by that guidance, I think is really important for professionalism. And especially when you're in a large organization like a government agency, just for the smooth operation of the agency generally. Of course, you'll hear us say regularly that the rules of professional conduct are rules of reason. We rely on this quite a bit when we're providing guidance. And of course, always remember the larger context of the rules that we're talking about today. You have government ethics rules. Sometimes there's an overlap, and our papers have sort of tried to focus on those areas where there is an overlap between the legal ethical obligations you might have as well as your government ethics. And Rashee or Asia are going to be jumping in to kind of flag some of our scenarios that also carry implications under the government ethics rules. And of course, there's also substantive law that we are all subject to every day. So that said, I think I will let Nakia kick off the hypos here.
Okay. So Linda works as an attorney advisor for the DC Department of General Services. She is only licensed in the District of Columbia. She would like to start a side business. Her two options are starting a tax service or an online boutique to sell handmade quilts. Which business can she start without running afoul of the DC rules of professional conduct? A, the online boutique. B, the tax service. C, both. Or D, neither. You can put your answers in the chat and we'll just give you about a minute or so to do that.
Some C's.
Yeah, quite a few C's.
Good. An A.
Okay, Erica, I think we'll go to the next slide. The majority looked like they were C's. So
Just get this advanced.
So the best answer is C. A lot of you were correct, both. What we would do first, if this question came in on the helpline, would of course start to analyze it under Rule 5.C, which is essentially the responsibilities regarding law-related practice. And Erika, you can jump in. I always start from 5.7B and then go up versus start at 5.7A down, because when you read 5.7B, it says the term law-related service denotes services that might be reasonably performed in conjunction with and in substance are related to the provision of legal services and that are not prohibited as unauthorized practice of law when provided by a non-lawyer. And so I'll add, what is the unauthorized practice of law in DC is not something that's in the DC Rules of Professional Conduct. It is in DC Court of Appeals Rule 49. We're pretty familiar with that, but we usually still always tell people, make sure you go and look at the rule yourself, but there's a pretty extensive list that kind of outlines those things. So if you are doing something like building a deck, like our colleague Saul Singer has a famous article that a lot of people have read that we always reference, about a lawyer who wants to build a deck, essentially, that's so far removed from, of course, it's not something that someone would get in trouble for, the unauthorized practice of law. So that's usually kind of like a green light, go ahead, you're fine. Of course, there are other rules that come up when you're interacting with clients and other businesses, but you're pretty much okay to just go ahead and do that. So the quilt business, probably fine, or definitely fine, to the extent that we have our say so. I think when Erika mentioned that we're different from the Office of Disciplinary Counsel, some of you may have heard the disclaimer that many of us give at the beginnings of our call, that essentially says that we don't provide a safe harbor, we can't bind the Office of Disciplinary Counsel or the court. So we usually will say, this seems like something safe. You can open your online boutique and sell your quilts. Now, if you're a tax lawyer opening up a tax business, that's where the kind of yellow, slow down, proceed with caution. There are some things that you need to be aware of, and there are some things that you probably want to do. Erika, can you go to the next slide? I think the comments. So comment 2 talks more about making sure that if you are in that kind of gray area, if you've gone from I have the green light, I can go ahead, sure, no, the issue of quilts or building a deck, fine, but now I'm kind of getting close to what I do every day and what people interact with me on a daily basis for. I need to kind of slow down and think through. I need to give warnings to clients so that they understand that my services are separate. When I'm doing something, I'm separate. I may be a lawyer, but in this situation, I'm not their lawyer. And that they understand that the rules of professional conduct wouldn't apply to that relationship. Now, there will be some instances where all the warnings in the world still, may not matter. What forms an attorney-client relationship, or the facts that form an attorney-client relationship, are a matter of the substantive law, and they usually, look to the client or the individual at the time. Of course, it's going to inure to the benefit, the life most favorable to the layperson, if you will, kind of in their understanding of things. Next slide, Erika. And so even comment 9 kind of says, there are examples of these law-related services. You're a real estate agent, you're opening a title insurance company, financial planning, accounting, things like that kind of get in the area of where you want to be very careful in making sure you have your disclaimers. But again, even so, when you go back to the thrust of Rule 5.7, there still may be such an overlap that there is no distinguishing one business from the other. And the expectation of the client, even though you gave those disclaimers, is I thought that this person was my lawyer. Yes, they did my accounting and they did my taxes, but this person is also a tax lawyer, and that's why I went to them. Or, they're so intertwined that they can't be separated. I don't know, Erika, next slide. Or I think,
There.
did someone want to jump in at the end? I couldn't remember if it was at the end of slide 9 or comment 9.
Let me see. I'll go ahead and advance this. There were any questions in the chat that I just missed, or?
Uh,
No.
I don't think
I didn't
so.
see any.
Nothing in the chat.
Okay. There we go.
Okay, so just a note about pro bono public service. We get a lot of calls from the helpline, or I should say a fair amount of calls from the helpline, people panicking about their yearly pro bono expectations. So in DC, it's aspirational. If there's no enforcement of the rules, should you not provide any pro bono services or make that donation. And so I say that because it also leads into our next question, where we get a lot of questions from government lawyers about pro bono service and things of that nature. So, Erika, next slide.
There we go.
So Danica is an attorney advisor for the Office of the DC Inspector General. Her law school alumni group is volunteering at a one-day clinic put on by a legal service provider. Must Danica clear conflicts for each person she plans to see at the clinic? A, yes. B, no. C, she can't volunteer because her position conflicts her out of too many things. And again, you can put your answer in the chat. A couple of A's.
Good.
I think mostly A's. So Erika, we'll go to the next slide.
This was actually B, I think was the answer here. B, right?
B, no.
Yeah.
Yes. So when you look at Rule 6.5, the fact that Danica is assisting at and these are, of course, according to the rules of professional conduct. I think Rashee and Asia will maybe join in later, and if there are different rules that come directly from DC. But under DC rules, again, because DC is so, aspirational and pushing pro bono and really great with the pro bono work. And we have a lot of self-help clinics, a lot of self-help resource centers down at the courthouse. This rule essentially says, lawyer, if you're participating in a same-day clinic that is offered by a nonprofit, you don't have to check every person through your conflict system. Now, if you know that there is a specific conflict, then of course you can't help that person. But if you don't know, you can help that person. Of course, if Danica is seeing someone that has a case against maybe DC Housing Authority or has a real property tax assessment issue, you of course back up from that matter. But if she has something, a case against a small landlord, Jim Doe from down the block, you can see that person, you can see her and not have to worry about conflicts. If you go to the next slide, Erika. Where it becomes more of a wrinkle is if you are doing additional work after that clinic. And again, this rule doesn't apply to any long-term service clinics. The Pro Bono Center has, several clinics, and they place long-term cases. Those cases would have to go through conflicts, and anything after that same day in-person meeting would trigger a conflict. So, usually at, let's say, a Saturday clinic or at a resource center, you may help someone and you may say, well, let me go back to the office and kind of draft a letter or do a little bit more research. Then you're triggering 1.7 and 1.9 requirements. Next slide.
This might be the place to jump in as far as where government ethics will be implicated would be under 1807 outside employment and private representations. And I don't think there's a whole lot different from what you said. As far as under 1807.1H, serving in a representative capacity or as an agent or an attorney for an outside entity involving any matter before the District of Columbia is the part that is prohibited, with certain exceptions, of course, and those are under 1807.6 and 7.
I think we also have some carve outs for pro bono,
Pro bono.
specifically. I want to say specifically for Office of the Attorney General. But
Yeah.
I would have to take a closer look at the rules, but there is carve outs for the pro bono. And so generally representation of any third party before the district would be prohibited, but there's that carve out for the pro bono.
Yeah, and I'll put it in the chat here. It's
and
under the
someone
conflict
just-
of interest section.
It's great. And someone just pointed out the OAG and MOLC both have their own, guidance on pro bono representations. It's great.
Next slide, Erika. But I think
Yes.
it's you next.
Okay. Oh, so it goes to me. I'll just add real quickly before we switch, because I noticed a lot of people put in A that you should always check conflicts. And it's good to the extent you've sort of been drilled with the idea, like you need to be really careful when you're undertaking a legal representation to check for conflicts. That's a good instinct. The idea is that when you're at one of these clinics where there's just, no reasonable way of doing it, you're exempted from that obligation unless you take a look at the person or the name and you've got a problem. So
There is one question someone put in
yeah.
the chat. Well, first, there's a statement about getting that information from Elaine Block. She's actually on one of our committees, so she's a great resource both for the DC Bar and for government lawyers. And then the other question is, who can we get that guidance from at MOLC? I'm assuming Rashee or
Mayor's
Yeah,
Office of
Mayor's
Legal
Office.
Counsel. I'm not sure who exactly at the MOLC, but I would say just reach out directly to Vanessa, because she can at least point you in the right direction. Vanessa Natali.
Very good.
And she may just point you back to us too, which is fine. You can always come to us.
All right. So good. So, all right, moving on, where we've got our next hypothetical, question 3. So Kevin is a lawyer with the DC Office of Tax and Revenue. He's considering opening an investigation into a developer, Big Build DC, and their compliance with its tax obligations. When Kevin tells Marty, his boss, Marty directs Kevin to open the investigation ASAP because he knows that Big Build DC is corrupt. Marty further explained that he knows of the corruption based on his work as a volunteer mentor to a handful of young leaders of DC nonprofits that are focused on housing issues. Marty helps them develop goals and strategies to further their organizational missions. Marty assures Kevin that he has obtained all the necessary approvals for this outside work, and that his work with the nonprofits is non-legal in nature, so there cannot be a conflict of interest. He further adds that the nonprofits are very grateful for his assistance and recently named him Volunteer of the Year. So, in these circumstances, does Kevin follow Marty's instruction and quickly open that investigation into Big Build DC? So 3 options. Yes, because Marty has already addressed conflicts and disclosures. B, no, Kevin should gently get Marty to assess whether he has a personal interest conflict that may require recusal. Or C, yes, because Marty's issues are not Kevin's problem. Kevin can do as instructed unless he thinks the instructions are clearly problematic. We've got some B's here. 1A. Lots of B's. And an A. All right, so this is good, and I think I'll just go ahead and get to the next slide. We're mostly B, a few A's, and I didn't see anyone going for C. C, thank you. We got a C. So this is a intentionally sort of a difficult interpretation. I think the answer we would give on the ethics helpline is B. Gently get Marty to reassess whether he has a personal interest conflict that may require recusal. Now, how one can gently get their boss to evaluate whether they're engaging in ethical misconduct, that is, we would say that's beyond the scope of our service. That requires some skill in managing up, correct? But here's what I think Kevin should be hearing when he hears Marty talking about all this information he has about big build, and you know, it's personal interest conflict. It says, except as permitted by paragraph C, a lawyer shall not represent a client with respect to a matter if the lawyer's professional judgment on behalf of the client. And here what we're talking about is basically Marty's judgment on behalf of the Office of Tax and Revenue, right? He's supervising Kevin. He's given Kevin advice about how to conduct this investigation. And the question is his judgment adversely affected by his responsibilities to or interests in a third party or the lawyer's own financial, business, property, or personal interests? Now, for those of you who chose A, I think, which said, look, he's already cleared the conflict, that it's not a problem. That's not unreasonable, right? That's basically what Marty said up front in the hypothetical. And 1.7b4 conflicts are waivable. It said the lawyer may represent a client with respect to a matter in the circumstances described in paragraph B above if, and actually, like Nakia, I like to start with the prong that makes more sense first, which is 2 in this case. The lawyer reasonably believes that the lawyer will be able to provide competent and diligent representation to each affected client. So that would be, you know, Marty's essentially evaluating that. Like I really like this organization, but I don't think my affiliation with or interest in or support of this organization affects my ability to provide good advice to my employer. And so if you overcome that prong, then the second one is 1, each potentially affected client provides informed consent to waive the conflict in essence. So what Kevin is supposed to respond to here, and this is difficult, is like, you can be telling me that this is not interfering with your judgment, but at the same time, you've just told me it is, right? You're telling me to open an investigation because you have this information from an outside source and you're very loyal to this organization. They've rewarded you with Volunteer of the Year, or they think you're a great advocate for them. Is that why you're instructing me to open this investigation into this developer? So that's the problem. And I'll mention another thing. My understanding, and once in a while I hear someone say, no, it's okay, but I think getting a 1.7C waiver in any government agency is all but impossible, right? If you're going to an agency, their legal counsel or ethics counsel and saying, I might have a personal interest conflict here, but here's why I think it's not a problem. My guess is that the agency is not so much going to say, sure, we're going to give you a waiver here, as say, thank you for telling us either, we don't see a problem here at all. We just don't think there's a conflict, and so you may continue. Or alternatively, they'll say, thanks for telling us. Yeah, we're going to substitute in another one of our OAG attorneys or another one of our tax attorneys, right? They'll just do that to solve the problem, as opposed to sitting there and trying to weigh the conflict. So anyway, that's just sort of food for thought in how you evaluate this this conflict. You know, I can't say that A and C are clearly wrong. You know, C, you know, at the end of the day, is a junior attorney really going to get into trouble for not appropriately evaluating his senior attorney's conflict of interest? Probably not. But again, it's sort of a best practice. It's something that you should be looking for. And at the end of the day, I think Marty would thank Kevin for reining him in here. Any questions on this?
There's none in the chat.
None in the chat. All right, very good. Then I will just move along here to the next one. Okay. So Warren is as a lawyer for the Office of Administrative Hearings. He is mowing his lawn on Saturday morning when he hears a fight between his next door neighbors. Patrice is a lawyer in the domestic violence section of the DC OAG, and Rachel is a teacher. As the argument moved outside, Patrice picked up a pot and threw it in Rachel's direction. It crashed at her feet. The police were called and asked for a short statement from Warren. So, under the rules of professional conduct, does Warren have a mandatory duty to report what Patrice did to the Office of Disciplinary Counsel? Got a B for no. Thought I saw a flash of an A there, but maybe not. There's some A's. This is good. I mean, and again, it reflects these are not always straightforward analyses, and there's not always one entirely correct way to interpret these hypotheticals. But that said, I'm going to go ahead and jump to the next slide here. And I think the best answer for this hypothetical, and again, well, this is sort of where I would end up here. I think B is the correct answer. When we get these types of questions, in particular on the ethics helpline, we are excruciatingly careful about trying not to weigh in. And instead, we try to sort of say, look, this is the analysis, but you've got to do it yourself. The way I would approach this particular hypothetical. Oh, so that was, I'm gonna jump to that question. It looks like an interesting question. It relates back to our last hypothetical. Let me get through this one and I'll go back to that one. To have a mandatory reporting duty to the Office of Disciplinary Counsel, of course, there has to be a rule violation, or the lawyer has to believe that there has been a rule violation. And the only rule I can think of in this situation, and you know, we've got a domestic violence situation, it's totally unrelated to the practice of law. So we go to 8.4, which is sort of the 24/7 general misconduct rules that apply to lawyers in all facets of their lives, including their personal lives. And the most applicable rule that I could find would be, it is professional misconduct for a lawyer to commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. So on some level, to conclude that a person has broken this law, you know, I don't want to say that they have to have been convicted of a crime. You know, you can certainly know that a person has committed a crime without them having been adjudicated as guilty. But this one is a little bit, I think it's a little bit uncertain exactly what happened here. And certainly, so I would leave it, I would say there's a little bit of a question here. Do we know for certain that this would be considered a criminal act? And then on top of that, you know, this is just the rule that she might have broken, Patrice might have broken. We get to 8.3a, which is the mandatory reporting rule. And this is the rule that's, you know, so you kind of have to layer these two rules together. 8.3a says a lawyer who knows that another lawyer has committed a violation of the rules of professional conduct that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects shall inform the appropriate professional authority. So this is always a fascinating rule to help people evaluate, because there are clearly so many ways to sort of read yourself out of having a mandatory reporting obligation. we've got actual knowledge, right? And a lawyer who knows that another lawyer has committed. And then there's got to be a violation of the rules of professional conduct. That violation has to raise a substantial question that is totally undefined in the rules as to the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. So this hypo, if it came to me on the helpline, I'd probably do exactly that. Say, look, you know, you have to make your own decision. You have to make your own analysis here. And to be clear, like, you know, in a situation like that, this is not to downplay the importance of addressing domestic violence in any way. But I think my initial thought would be like, if you think you're seeing domestic violence, I think my first call would probably be to the police. Now, I think in the hypo, the police already came out. But it would be following up, making sure people in the house are safe, making sure children in the house are safe, that sort of thing. I think that's the primary concern. And then the other thing about mandatory reporting is that sometimes it takes time to come to a conclusion that there's a problem that requires a mandatory report, and that's okay. There is not a timeline on making these types of reports, so that decision to not report can always be revisited. The other point I'll make is, even though I just made the argument that there is no requirement for the lawyer in this hypothetical to make a report, there is permissive reporting. When a lawyer is thinking about just saying, look, I don't really know, I don't think I'm obligated to make a report, but I'm concerned enough that I'm going to make a report. The only real limit there is going to be Rule 8.4G, and that rule says it is professional misconduct for a lawyer to seek or threaten to seek criminal charges or disciplinary charges solely to gain an advantage in a civil matter. Again, where this comes up most often is where you've got two lawyers already embroiled in a civil litigation, and they are coming up with ethical violations that they want to report that might not appear to be entirely in good faith. And certainly so lawyers would run into a risk of an 8.4G. So that's a good question. I will get to that in a second. 8.4G gets triggered in those situations. It also gets triggered when one lawyer gets mad at another lawyer and starts saying, I'm going to report you to the Office of Disciplinary Conduct. That is, we always advise people, look, if you think you've got an ethical obligation, or you have the right, you have permission to make a permissive report to the Office of Disciplinary Counsel, just do it. Don't try to talk to the other lawyer about it. It is very, very rare that you are going to do anything other than open up the possibility that you're threatening somebody if you try to engage with them about their ethical misconduct. Again, if I'm trying to come up with an exception to that one rule, it's going to be in the case of a client fires a lawyer and moves on to successor counsel. Successor counsel is trying to get a copy of the file from the prior lawyer, and that lawyer won't give it up. They either say they're mad, or they won't give it up because the client hasn't paid their bills. That becomes a massive issue for the next lawyer who might have a deadline that they're working under. So in those situations, I think lawyers sometimes do resort to, look, I've asked several times for the client's file. You're not giving it to me. My next call is going to be to ODC because I have to look out for my client's interests. That's about the only situation I can think of in which a lawyer might safely raise that possibility. Final, Ethics Opinion 220 sort of talks about permissive reporting as opposed to mandatory reporting, and that's a useful resource for anyone who's interested in questions. Back to the question about the fitness prong, right? Nakia, are you able to see that question in the chat? Sorry, I think
You're on mute.
there you go.
Is there any guidance on what factors bear on the fitness prong of this mandatory reporting duty?
It's really hard, right? And it's it's funny, if you go back to the text of the rule itself, I remember this has always sort of fascinated me. This says, it is professional misconduct for a lawyer to commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. So, I mean, maybe this makes sense. It's always a little bit shocks me, but I could almost make an argument that a lawyer who gets drunk in a bar and punches somebody in the face is less likely to have violated 8.4B than, you know, a lawyer who does something sneaky with someone else's $10, right? That it really goes, you know, fundamentally, I think that the primary interest is honesty and trustworthiness. And fit certainly a lawyer who's, you know, regularly driving drunk. I mean, at some point, it's almost like the standard is bringing disrepute upon the profession. So domestic violence could certainly fit into that category. Again, I tend to think that the primary concern in those situations is, again, ensuring everyone's safety, and then you can get around to making reports as opposed to thinking immediately, oh my God, what are my ethical obligations about reporting this fight between my neighbors? But it's a good question, and I think it's a little bit open-ended, and you know, I think
Erika, I think what you were saying earlier about you can talk yourself in or out. Like if you talk yourself into it by saying, well, this is evidence of a mental health issue, which of course bears on how fit a lawyer is and their ability to represent their client and do their due diligence, or this person just has a hot temper, and these two individuals don't get along, but you know, this individual is perfectly fine when it comes to the other neighbors and wouldn't do that. And so no, there, of course, it doesn't reflect on their mental health and their fitness. So I think, you know, again, that goes to earlier what you were saying about being, unless it's very something that's like very clear cut, that directly, if it's something that is honesty, trustworthiness, that's very clear cut. When you come to the third prong of fitness, that's where, you know, you have to, as the lawyer, do that specific analysis and kind of argue yourself in or out of it.
Yeah, and again, none of this should be taken as any way minimizing this. There's a, you know, unfortunately, there's just been, well, two kind of reports on domestic violence episodes recently. One, a Maryland judge, I think, was just killed in his driveway last week for having forced a father out of his home because of domestic violence. And the man came in and shot him. So that's, you know, it can become a crisis pretty quickly. And another, you know, a somewhat high profile, yeah, so I know it's gotten a lot of press, and a somewhat high profile member of the bar, a law professor locally, was just arrested for domestic violence. And I don't know what the outcome of that is going to be yet, but it doesn't sound good. So
There
anyway,
was an
food for
update
thought.
on that news story, like right before this session started, that the person who shot the judge, I think, took his own life, and they just found him this afternoon.
You know, not a surprising outcome. I mean, it's just so tragic all around. So
Glenn had a comment in the chat, and I think it segues really well into your next question.
oh, good. Good. So should I just go on to the next question then?
Yeah,
Or
or I'll read the comment to you, and then you can.
Oh, that's
go
good.
right on.
Okay, great. That's
I'm
great.
concerned the district is losing because no investigation is being started. Could Kevin open an investigation without Marty's input, maybe reporting to Marty's supervisor?
So that goes to that last typo when you've got you know, Marty saying, so no, that's a really good point, right? Just, you know, it could be that Marty's overly invested in telling you to open an investigation for the wrong reasons, but that doesn't mean there's not a good reason to open the investigation. And I think that the hypo is meant to say it's not so much that Kevin can't open it, it's that he shouldn't be opening it solely because someone in a conflict position with an interest in it that is sort of overly personal shouldn't be directing it. So I think would be the ideal outcome if he either says, hey, Marty, kind of snap out of it. You're obviously way too invested in this organization and you have this little bit of an animus here. Why don't I work on this matter and report up to someone else instead? That is the ideal solution, I think, in those situations. Because
I was just going to jump in and mention that as on the ethics side, I could think of two rules that would potentially be implicated. The first one being the requirement that we do our jobs impartially. So the district personnel manual rule is 1800.3H, I want to say, about impartiality, right? And then as it pertains to the junior attorney, his responsibility would be to report it to us, right? If the supervisor is potentially violating 1800.3H, then you report it to us, and we'll figure out whether or not he's doing this job impartially. If he's pressing for an investigation for any other reason besides professional, and he's convinced based on the evidence that the junior attorney presented that there's something there, then we might have an ethics issue.
And that is, yeah, that's a really good analysis. And I think that really kind of parallels, how we would describe the personal interest conflict in these situations. So that's where the government ethics and the legal ethics rules dovetail really nicely.
Erika, can I jump in to give the code because we have about 10 minutes left?
That's great. Thanks, Nakia.
So the CLE code is AV87. I'm going to try to share my screen. They sent over the PowerPoint with it. So it's on your screen now, AV87. And then I'll leave it up for about another couple of seconds. And then Erika, you can go back to sharing, or I can stop. And I'll put it in the chat if anyone missed it.
Good idea. Okay. All right. So we're working with the same hypo with Warren and his neighbors, Patrice and Rachel. So same facts, but this time assume that Warren works as also a lawyer at the DC Office of Attorney General, same agency as Patrice, who threw the pot at her wife's feet. Should Warren be thinking about his reporting obligations in a new light? No, because Warren still has no actual knowledge of misconduct and this doesn't change anything. Or B, yes, because Warren now needs to take into account the organizational interests of OAG. This is good. We're getting a little bit of a split here. And again, this was a little bit of a trick I'm playing, because in theory, the mandatory reporting obligation doesn't change. I would agree with that. There's no difference under, looking at 8.4B or 8.3A. But when you're a lawyer within an organization, there is another rule that becomes important. And so that's what I was trying to get at here. So I think the best answer is B, because Warren now needs to take into account the organizational interests of OAG. And if you look at this rule, it's kind of a long one. But it says, if a lawyer for an organization knows that an officer, employee, or other person associated with the organization is engaged in action, intends to act, or refuses to act in a matter related to the representation that is a violation of a legal obligation or a violation of law which reasonably might be imputed to the organization and is likely to result in substantial injury to the organization, the lawyer shall proceed, as in the best interest of the organization. And then if you look down the bottom, normally that's going to involve referring the matter to a higher authority in the organization. This is kind of a fascinating rule because I actually think it's written in a way that's sort of unclear, especially as compared to 8.3A, where under 8.3A, the lawyer has to have actual knowledge that another lawyer has committed a violation of the rules of professional conduct. This rule, in some ways, the language parallels that, but I think this is a different kind of knowledge. I think the knowledge here that I would argue that Warren has is that, this looks bad. Here I am, an OAG attorney. I just saw the director of the domestic violence division do something that looks like domestic violence. And not only that, the police came and I gave a statement. I can't just go about my day and do nothing. I see that unbecoming behavior. Or you might have appearance of impropriety. That's not an ethical standard anymore, but so related to the representation. That's a fair point. I guess what I would say here is, in my mind, the problem is, well, This is a little bit vague. Again, I've never heard of a lawyer being disciplined for violating 113B, but I'm thinking if I'm a lawyer and I know my next door neighbor who has a senior role in the Division on Domestic Violence is engaging in this kind of conduct, and I gave a statement about it to the police, I feel like I got to march in and I've got to do something about this, right? Like this looks bad. This is really a problem for the organization. Again, it becomes difficult when we're talking about OAG and this idea of a matter related to the representation. I'm not sure that this rule fits perfectly the OAG model where you've got all these different lawyers who may at times be representing OAG, may at times be representing individuals in agencies, right? It's a little bit tricky. I still think that the knowledge here is that this could really blow up and look bad for OAG. And so that's why I would sort of say you should take some action. This is a fair question. That's a fair question. Does it, what if it was totally unrelated to the lawyer's specialty? I mean, again, I have a hard time imagining a situation where a lawyer who's required to use an extensive amount of judgment to comply with this rule would be disciplined for making the wrong analysis. But you can read yourself out of this rule if you want to, just like 8.3a, you can come to the conclusion, well, it's just not enough of an issue. I would still tell anyone as a best practice, this is something you probably want to make a report about. And here's something that might make this all a little bit more palatable. To whom should Warren, the lawyer, make his report? Does he do it to BEGA, B, OAG, supervising attorney, or OIG? So this might be, yeah, all right, this is good. Since we're running a little bit short on time, I'm going to just jump ahead here. Is an appearance of impropriety? Yes, appearance of impropriety is still applicable to judges. So when something looks bad, the standard is different. The judge probably has to do something. So I'm going to just skip ahead here, though. I think the right answer here is C. And the thing is, this makes it a lot easier, I think, to stomach making what might feel like an awkward report or the busybody report of the neighbor who's witnessed something that was untoward, to say the least. All 113B says is reported up. This is exactly when you lean on your manager and say, look, I don't know how to handle this. I don't know if it needs to be handled, but let me just tell you, I did have to give a statement to the police and it was about this. And I'm going to leave this in your hands to figure out what to do next. And if you're reporting that to a supervising lawyer, they have a responsibility to appropriately manage that situation. And they might say, go right to human resources, go to, I imagine every every agency is set up a little bit differently. So my answer in part rests on Rule 5.2 and subordinate lawyers. And this is just what we call a limited safe harbor, but it's a really helpful safe harbor to lawyers who are being supervised by another attorney. And B says a subordinate lawyer does not violate the rules of professional conduct if that lawyer acts in accordance with the supervisory lawyer's reasonable resolution of an arguable question of professional duty. So I think that's helpful. And just a few quick general points about reporting misconduct. When you're talking about reporting it out of an agency, like making a report even to the Office of Disciplinary Counsel under 8.3a, you have to remember that all of those reports, they are subject to Rule 1.6. 8.3c actually sort of modifies 8.3a and says this rule does not require reporting of information protected by Rule 1.6. And that, of course, is the confidentiality rule that we always are talking about. So that is a limit on reporting. And it really just wasn't in play in these hypotheticals. And the other thing is when we're talking about when you're a government lawyer, when you're an agency lawyer and you're thinking about making a report, almost always, you can't really think of a situation in which you would want to make that report as an individual. You'd probably want to run that through, your agency general counsel. You know, you take the information you have, say, I think I've got a mandatory report here, but I'm taking this to you to evaluate and make the report. And that is pretty standard. It's good because it ensures that you don't have lawyers making their own ad hoc judgments. You know, it means there's a little bit more uniformity to the process. And it also, you know, it protects lawyers who might be accused of acting out or making improper reports, that sort of thing. So is there anything I missed in the chat that we should address quickly? Good shape.
There were some, I think, follow-up questions to the initial question.
Apply for a safe harbor opinion. So for the type of, so there are no safe harbors, unfortunately, from the DC Bar Legal Ethics Program. And we are really, really confident about the legal ethics opinions we have issued. And when we go and write sometimes we'll commit things to chair letters or staff letters, and we're confident that we think that is the right outcome. We're working hard to give good advice, but even in those letters, we have to say, this is not a safe harbor. With respect to our opinions, I think there has only been one opinion that a DC Court of Appeals has ever disagreed with, and it wasn't even a direct disagreement. It was, 15 years later, they gave advice that seemed to be a little bit in conflict with something that we had written in an ethics opinion. That was that had to do with a disciplinary case in Ray Mance. It's ethics opinion 355, and it deals with lawyer trust accounts and how to move money in and out of a trust account. So not really relevant for us today. But anyway, so I guess what I'm saying is it's hard to get a safe harbor, but what you can get when you call us is that informal guidance. And, sometimes we all confer, and you can ask us to confer, and you can hear, all four of us think under the fact pattern you've described that this is the right thing for you to do. But again, at the end of the day, we can't give you a safe harbor, but I can't help but think that it would be helpful for you if you're ever asked to explain why you did X, Y, or Z. If you say, I did that, I tried hard to get it right, I called the ethics helpline, I suspect that's got to be helpful or mitigating in some way.
We do have safe harbor, but I just generally, it doesn't really relate to this particular harbor because I don't think we have code of conduct violation.
That's interesting. So go to BEGA if you want safe harbor.
But the safe harbor is only in place when you act in accordance with the advice that was provided, right? It does not necessarily link to like our advisory opinions. It's like, hey, I didn't contact you guys or talk to you at all, but I followed what you said in this advisory opinion. It doesn't work that way. You have to contact us. We have to give you advice, based on your particular circumstances. Yeah. Okay,
that's interesting. It's a little bit different. So, Rashee, yeah. So I don't know. I guess we might have to pull the plug here. Thanks, guys, for participating so much. It's so helpful to get people asking questions and throwing their answers.
If you'd like to finish, we started a few minutes late. If you want to try for the last one.
Oh, that's great. If that's okay.
And then if anyone has to leave, I guess they can head out. I mean, I guess they've got their code at this point. But the last hypo is pretty good. So I mean, it may as well.
Great. So let me, I'll go over that quickly. And I guess I'll say anyone who had questions after the presentation can always call the ethics helpline numbers at the front and ask us. We'd be happy to go over that, either Nakia or me. So the last typo, sorry, I gotta get this. Warren leaves OAG and opens a law practice with one partner, a prospective client whose issue he examined in his former position at the Office of Administrative Hearings comes in the door. Can Warren have his partner handle the matter so long as Warren is screened off? A, no, because you can't do anything under the rules of professional conduct. B, yes, because a screen cures everything. C, no, because this has the appearance of impropriety, so it's popping its head back up again. Or D, yes, so long as he is screened and complies with all of the other requirements of Rule 111. All right, everyone is going straight to D, which is a screen plus. And I did this in a slightly angry and resentful way. I put up all of Rule 111, which is the conflicts rule that governs former government lawyers. It drives me nuts. It goes on, and I'm just going to go back. I mean, this is a lot of text for you to absorb. And the tricky thing about this rule, and I like to go over it with people at the same time. You're not going to remember this and apply it to yourself 3 years from now or 5 years from now when you're leaving government and going on to open up your own firm or joining a firm in the private sector. It's something that you kind of have to I just want to flag for you that this is a complicated analysis. It's not intuitive in the least, and it's very inflexible. So you need to get it right off the bat. But you can see it's a long rule, very lengthy here. In addition to doing a screen as required in this hypo, the other things that the lawyer, Warren, would have to do is avoid sharing any fees from that representation. That's in Part C below. And he also has to comply with paragraphs D and E, which are these, what I consider kind of crazy notification obligations. I was going to try to look this up. I can't remember if this is in the Brown versus Board of Zoning case, or if it's there's something called In Re Revolving Door, which is the case in which the DC Court of Appeals approved this rule. But there was some objection to it because this rule, I mean, it's one of the only rules that you violate this rule if you fail to announce in triplicate in writing that you're complying with the rule. And it's sort of an absurd thing. You're not complying with the rule unless you send all of these notifications that you are complying with the rule. So it's an onerous, it's not easy to comply with this rule is what I'm trying to say. Other important things that I want to just remind you about the Rule 111 analysis in general. In most conflicts rules, we're talking about adversity, and you can see harm to a former client. There's an obvious reason for it. When we're talking about Rule 111A, there just has to be a connection. There just has to be a connection. So you're not going to be triggered by the thought of, oh, well, my former client wouldn't like this, or this could be damaging to my former client. I shouldn't do this. It's that, because that's a lot easier to spot that kind of conflict. That is not the case in 111. So you don't get that help. There's also no ability to get this rule waived. You cannot go back to your former agency and say, could you waive this conflict for me? It is simply not available. There are no time limits. So this applies, 30 years down the road, long after you've forgotten whatever government, whatever meetings you were sitting through while you were in the government and potentially weighing in on issues. It is the one good thing is it is limited to legal matters. So does not include things that you might have done as a policy analyst while you were in the government, right? So if you're drafting legislation or, again, doing something that seems more like lobbying, that is probably not going to create a conflict of interest under this rule. That's nice. Thanks again for all of you guys. Bearing with me over the time here and for participating. It makes it a lot easier for Nakia and me to engage. So that was great.
And I just wanted to throw in there for this one, the ethics rule that we would probably come up is the post-employment rules, which are in section 1811 of the district personnel manual. And based on the hypothetical, I think he'd be prohibited from taking on he wouldn't be prohibited from taking on the client, the firm wouldn't, but he would be prohibited from giving his partner any behind the scenes counsel with regards to the matter. And the behind the scenes rule, I think that's 1811.8.
And to answer Camille's question, you have free post-employment advice for life from BEGA. So if you leave and you take a job and then you take another job and that one you think relates back to your DC government work, reach out to us.
Yes, post-employment is complicated. So just reach out to us and we can give you an informal post-employment advice, and you can give it to the new employer, follow it. And if there are any small confusing things that come up, just contact us so that we can kind of guide you through it.
There was one question, I'm not sure if we got to, and it was regarding if your former lawyer won't provide you your records of your representation, would it be appropriate to legitimately threaten them with Office of Disciplinary Counsel?
So if this is, so I guess I would say you want to be really careful with that, especially if you yourself or you're a lawyer and you're acting in your personal capacity. And part of the reason is there is a very limited right that lawyers have to retain their own work product if client hasn't paid for work product. Again, we generally advise people not to try to take advantage of that very narrow exception. I think it's the 1.8I or something. Does that sound right, Nakia?
Yes.
Okay, so
8I.
yeah. So you just don't want to get into a situation where there's an argument. So I guess I would say in general, I would never advise making that threat. But if you're in a situation where you feel like a lawyer owes you a file, you could always come in and talk with us about ways to resolve that. Honestly, I'd almost rather have another lawyer in place and say, you do the dirty work for me and get this file pried out of that former attorney's hands. That makes sense.
I'll just say the code one more time because I see someone said they didn't see it. The CLE code is A as in Apple, V as in Victor, 87. And I also put it in the chat again.
Great. Thanks so much, everyone. Thanks for sticking with us.
Yeah, thank you, Nakia and Erika, for being here. We love having you every year.
Yes,
Great.
thanks, guys.
Well,
Thanks for
thank
doing
you.
it again.
Okay, good.
All right. Thank you, everyone. Bye-bye.
Bye.